Well, I've been judge of the county court for just over 12 years now. Initially, when I got into the law, that was as a solicitor with Criminal Law Division of Legal Aid, now Victorian Legal Aid. Following that, I went to the bar and was a barrister for about 12 years, doing both prosecution and defence work in criminal law. And my last 5 years or so before being appointed a judge, I was a senior Crown prosecutor at the Office of Public Prosecutions, dealing solely in prosecution work. So I specialise in criminal law and have done since I commenced in the law.
Fantastic. Thank you, Judge Campbell. If I may, Judge Gaynor, can you please tell our audience how you started at law and your role at the court?
Okay, well, I've been a judge here since 2002, so nearly 19 years. And before that, I was a criminal defence barrister. In fact, I was often hotly opposed to Judge Campbell on occasion. And look at Ben, he's looking up reminiscently. There were some fiery scenes in those days. And before that, I was at Legal Aid for a year as a duty solicitor. I started off as a article clerk at a suburban firm in Camberwell, and I stayed there for about a year, and then I left law for about 3 years and worked as a journalist, and then I got a job at Legal Aid, so that was the way my path went. I've always done criminal law, but it's been on the defence side, and I always sit in criminal cases in the court here.
Thank you very much, Judge Gaynor. Judge Wraight, could you please tell our audience about how you started in law and your role at the court?
Well, compared to Judge Gaynor and Judge Campbell, I'm the baby of the group here. Although I've been at the court for 3.5 years now, before that I was at the bar for about 22 years, predominantly in crime and defence crime, although in the last few years before coming to the court, I was involved in occupational health and safety, both prosecution and defence work, and disciplinary work and white-collar crime. But since being at the court, I'm in the criminal division, and like Judge Gaynor and Judge Campbell, hear all sorts of criminal work, trials, appeals.
Fantastic. Thank you very much, Judge. And Ed, can you please tell our audience about your role at the court?
Sure. So I was in journalism for several years prior to becoming a member of the court's media team, and I've been here for about 3 years. So quite have a lot of contact with journalists day to day, and involved with Judge Gaynor on the court's media committee.
Fantastic. Thank you very much, Ed. We'll now begin the session with some questions that have been provided for our panel to start the conversation. But please feel free to type any questions you may have into the Q&A box at any time. Please note that our panel cannot give legal advice or comment on the specifics of a particular case. So to kick us off, Judge Gaynor, what role does the media play in the delivery of justice, and where do they fit into the system?
Media is incredibly important to the court because nobody really knows what goes on in a courtroom unless they come to court, which is not something that people usually do. It broadcasts the work of our court. It talks about the cases that we deal with. It talks about, it informs the public essentially about the work that we do and the cases that we hear. So it's extremely important. The community wouldn't know about what goes on in court really unless it was for the media.
Fantastic. And so, Judge Gamble, is it difficult to ignore the impact of media coverage when sentencing?
Is that in any case or any particular cases?
Any cases that you may come across.
Judges are aware of media reporting of cases as they are proceeding through the court. Some get more publicity than others. But in terms of that media coverage influencing any decision a judge makes, I can say from my own personal perspective, Judges Gaynor and Wraight may have observations of their own, but no, it doesn't influence a judge in the actual decision they make, because judges, by dint of their training as solicitors, as barristers over many years before being appointed, and then as judges, are trained to consider only the permissible factors that they had to take into account and to put to one side any impermissible factors such as pure prejudice or emotion or what view the media may take about a particular case. Sometimes there is a tenor in the way that they report something. Judges do have to take account of what the media is doing sometimes, not often. Something may be reported that's inaccurate to a material extent and needs to be corrected, and the media on approach are more than willing to do that in my experience. Or there may be some problem with a suppression order in place that the reporting may potentially infringe, or even the media are not allowed to report anything that may identify directly or indirectly the victim of a sexual offence. So we need to keep abreast of those matters. So of course we're not ignorant of what the media might be doing and reporting, but as Judge Gaynor said, they play an important role in reporting and educating the public when it's done in a balanced and informative way. But it plays no role in the judge's actual decision as to what the judge should do by way of sentence or finding someone guilty or not guilty in a magistrate's court appeal or judge alone trial.
Brilliant, thank you. And Judge Wraight, is there anything a judge can do to ensure that cases are reported on accurately, and what sort of orders are available to make sure, that can be made to restrict or prohibit reporting?
With the first part of that question, I think we have a role as judges to make sure the way we present our judgments and sentences is clear, and I try, I'm sure as does Judge Gamble and Gaynor, to use clear language for those parts of the sentence or the judgment that we really need to convey important messages about what orders we're making. But from the other side of the coin, for the media, what we've done in a practical sense is we've introduced some initiatives in the court to make the accuracy of our judgments and sentences, or to just make them more accurate to the reporters that are reporting on our cases. We have what's called the immediate publication protocol, and particularly with cases that might attract some media attention or profile in the community. With those matters, we do publish our reasons in the moments after we deliver them, so that the media has accurately a version of what we've just said. And so when that happens, again, if it's a case that's going to get a lot of publicity very shortly after, if there's anything that's wrong, then the media team has a good basis on which to correct that, because they say, well, you've got it, it's right in front of you. And so that's one initiative. The other we have is what's called the media portal, which has been in place for a while, where it's not a hard copy publication, but as we deliver our judgments, media can listen in and listen to the audio, which means you don't have to have everyone in court. Of course, journalists are busy people and have to be in a lot of places at once, and so that's assisted as well. And the other thing I think that has happened as a result of the pandemic is that we conducted a lot of our cases, as the rest of the world has as well, via Zoom or WebEx. And certainly in my case, and I know in other judges, there are students that may contact my staff and say, can I listen in? And we'll allow that. It's up to the individual judge, but that's now a new mechanism where many people can sit in and listen on the case with a request from our staff. So there are very practical ways that answer that question to make sure that media hear exactly what we've said, and so that they can report it accurately.
Fantastic, thank you. And further to that, Ed, what sort of access does the media have to courts other than physically attending?
Yeah, well, Judge Wraight just touched on, I think, the key to alternative access, and we certainly saw a massive increase thanks to the COVID pandemic last year. I think at last glance, it was over 13,000 hearings remotely heard since the start of the pandemic, which I think is a really big win for the courts. What was quite amusing in the pandemic was there was a narrative that the courts had closed, and it's true, physically you weren't able to attend a court. But what we found in the media team is that with the advent of WebEx and Zoom, we're actually almost more accessible than ever before, because communities in the regions who wouldn't necessarily know what was happening in a court matter that was relevant to them but was being heard in Melbourne or in another circuit court, they could observe, they could have their media representative observe the hearing and report those facts to the community. So in a very strange way, the doors were closed to members of the public for a large chunk of last year, but the courts were more open than we had been. So that was something quite interesting. And again, we are still in a hybrid model where many hearings you can tune into remotely, whether you're a student, a member of the public, or indeed a journalist. And I expect that to continue for some time.
Fantastic. We've got an interesting question coming through here. Are there situations where the media can jeopardise a case? And if so, what do you do in that scenario, Judge Gaynor?
Yeah, it's very easy for media to jeopardise a case, and the easiest way for that to happen is where they're reporting on a trial. And a trial is where someone's pleading not guilty and you've got a jury. And what happens in trials is a lot of what's called pre-trial argument, where there's argument where the jury are out and barristers will be making submissions about this sort of evidence shouldn't go in, or that evidence should be changed, or, you know, there's a lot of argument about what evidence should go before the jury. And so if a journalist reports on evidence on those sort of pre-trial proceedings, you know, where the jury's not there and there's arguments going on about evidence not going in, if they report about that, that can jeopardise the trial, because that means a juror can read about in the paper evidence that a judge might have said, no, this doesn't meet the rules of evidence, it's not good enough, it shouldn't go in. If you find out that that's happened, well, then you have to discharge the jury and start all over again. And that's probably the most common way that it can happen.
Fantastic. And so managing that potential impact, is there something that judges can do? I mean, Judge Wraight brought up the idea of suppression orders and those sorts of things, but is there something that judges can do in court to try and manage that?
I've started actually determining whether there is press in court, and say if there's press in court, someone's interested in a trial that I might be sitting on, I'll actually say to them, I mean, most good journalists know that they can, what they can and they can't report. But just to make sure, and it can be hard when you're a new journalist as well, and there's a lot of pressure on journalists now because they haven't got as many rounds people, so they've got to cover a lot of things. They can dash into one court, dash out of another, and not quite understand what's going on. So if there's press in court, I'll try and make a thing so you understand this is pre-trial argument, you can't report this. You know, and mostly journalists are extremely reasonable and would often sort of say, yeah, thanks for the heads up, because it can be really difficult. That's one way of doing it. But generally speaking, if it gets through the net and something is reported that's going to affect trial in that its material is out there in the public domain, that means a juror might get hold of it. Not much you can do apart from discharge the jury and start again.
Brilliant.
I think that's right. I think with what Judge Gaynor said about actually saying something in court, if it's a relatively run-of-the-mill sort of case and you know that there's not a lot of media attention, you may not say anything. But if it's a profile case, particularly through the pandemic, there's no one in front of you, but then your staff might say, oh, look, there's 40 journalists listening in. Now, of those 40, 30 might know the rules. And 5 might know them a bit. And 1 or 2 might not know them. That pre-trial argument cannot be reported on. And so if that is the case, I would say something at the beginning and say that this is pre-trial argument. It cannot be reported on because, as Judge Gaynor says, it might be a junior journalist who just thinks they're doing the right thing. They might be in another state. And all of a sudden, the whole trial can be blown because of a small mistake. So I think that when you're aware that there's more than just perhaps the mainstream listening in, to actually make a comment and explain the basic rules of procedure.
And it may be that a new jury and the trial may not be able to be commenced immediately because those who would form the panel from which the next jury would be drawn would likewise be potentially reading the media and be similarly prejudiced by what they had read. So it does have some significant ramifications.
So it has to go off for a while, you know, and you know, particularly if you've got an accused person who's in custody, that's sort of an injustice, but it can be the only way of ensuring a fair trial. So the consequences of blowing a jury, like Judge Gamble just said, can be really huge. It's an extremely expensive exercise as well. It sort of means all the costs for the time that the trial's already been running, the barristers, the solicitors, you know, getting another jury put together, all those sort of things still have to be paid for. So it's a fairly big issue for us.
And look, if a journalist is in any doubt about something, then they should contact Ed or the judge's associate to check whether or not what they're thinking about doing would cause any difficulty, I think, and their own editors and those who they would normally consult.
And you'd hope too that organisations, press organisations are sending people out who are newish to doing what's called court rounds, covering court procedures, actually arm them with that information. And we do a fair amount of talks to journalist students, and I just always say, if you're covering a trial where there's a jury, if the jury's not in the room, don't report it, and that's a good rule of thumb.
And a little bit further to that, say a journalist does breach that, are there any criminal consequences that could come their way?
It really depends, actually. If it's
Potentially.
but look, potentially there are. It depends on the circumstances. But say if you've made it very clear, you know, that you can't report this, and do you understand? Yep, and they report it. Yeah, there could be criminal consequences. I've not seen it happen, but yeah. Sorry.
Sometimes there's it's not just pre-trial argument, which there's an understanding that you shouldn't report, but there might be an application for an actual suppression order, and in those cases, sometimes journalists or media organisations are represented, and they'll argue it, and they'll say, well, look, we want to report this because it's of public interest, and defence will say, well, no, we've got a trial coming up in 6 months' time with a potential jury out there in the community. We don't want this reported. And so there are very complex arguments about whether the community needs to know, has a right to know certain things about the case, and simply being notorious is not necessarily a reason to shut a case down. So there's many different levels of how these laws work, and it's not always easy.
I mean, there's competing tensions there too, because there's the public policy in having criminal cases reported and the public being aware of them, versus another public interest in the accused person getting a fair trial. And sometimes they clash, and a judge has to make a decision as to which one wins out at the end of the day.
That's right.
It's easier with trials because you've got straight rules about, you know, can the trial proceed, can't it? But say sometimes you've got a particularly high profile plea where someone's pleading guilty, and press want a picture of, you know, of the accused person stabbing someone or bashing someone or something like that, you know, that we get a lot of requests for that. Often, sometimes you have to make a decision, and there's sort of a line that the public's got the right to know, not to salivate. So, you know, you will get something like, particularly television, they'll want some particularly graphic piece of information, and there's a whole body of law that's grown up around that about, you know, well, what's going to go viral? You know, how much damage is this going to make? Is this actually going to add to public knowledge, or is it simply sensationalism? And that's usually where we get the main arguments where media are represented, and someone will come along and say, you know, you should release this piece of film, you should let us have this photograph. Sometimes you've got to do a real balancing exercise. You say, you can have this bit of, they're called exhibits, you know, police photographs, police films, those sorts of things. You can have that, but you can't have that. So you've got all these sort of things to take into account, because it is meant to be an open court. But sometimes stuff, material is just simply too gruesome, too gory. It's almost like a snuff movie, and you just say, no, it's just not going
I think as a court, we are acutely aware of the public's right to know and open justice. They're very important principles. And that's why these sorts of arguments are very difficult for us.
Yeah.
Because as a court, we do the things like I was explaining before about protocols and education and groups such as the one that's listening now, so we can get the message across. But sometimes the interests of justice require that we just can't, at the moment, let that out.
Yeah. And further to that, I've got an interesting question here in terms of the actual making of a suppression order.
Yeah.
Are journalists able to place their argument involved? And if so, would there need to be a special hearing, or what would that look like?
If I'm handing down a suppression order, jumping in. If I'm looking at handing down a suppression order, and I know there's press interest, what I've started to do is, again, I'll identify what journalists are there, and I'll say, this is what I'm proposing to do, and this is why. Have you got anything to say about it? And that can be a bit tough on the journos involved, because they suddenly have to turn into barristers and make submissions. But I certainly always give press who are present an opportunity, and then in doing that, sometimes they'll say, look, we actually want to get legal advice on this. And if that happens, of course, you give them the opportunity to have legal advice, and you'll have a hearing about it. It's not a hard thing to organise.
Sure. And could that possibly be after the hearing that you're hearing at the time, or would that have to be a new day?
It depends. I mean, if you're sentencing right at the end of a day, or if the argument comes right at the end of a court day, yeah, possibly, although you could extend sitting hours. But, we're also aware of press deadlines as well. So you'd be fairly flexible about that. I would, be happy to stand it down for an hour or two so they can go off and get the representation one. And the lawyers that appear for the press are very, very familiar with picking up something at the last moment and running with it, because the arguments are pretty much the same. It's just fitting the contested material into it.
Sometimes you will get journos, because you're about to adjourn the case for the day, and there'll be journos in the courtroom, and it's not uncommon for them to simply stand up and say, can I be heard? Can we have access to the prosecution opening or some of the defence material? So that can happen too. And does happen.
And for journalists, when they are making those sorts of submissions, are there anything or any sort of topics or themes that the journalists might want to focus on to potentially convince a judge to make that decision?
It depends on the material, really. The more sensational and gory and the rest, in fact, Ed and I did a session recently with a number of sort of mid-range journalists about this. If you're going to get up and, if a journalist is going to get up and sort of talk about the public's right to know and use big vague terms about democracy and the right to know and all those sort of things, that's not going to be as successful than if the journalist concentrates on that material, why we want it, why it's important. So they need to be, would you say, Ed, that they need to be more specific?
And I think just as much notice as possible. Sort of a tip for new players: if you want to have a judge rule in your favour, try not to come in at the last minute. Easier said than done, I know, but I think that's very important. Just try and give as much notice as possible, because the judge will have more time to consider your argument.
Yeah, I mean, we regularly get requests from journalists, often through you, Ed, where they fill out a form and they tick the boxes about what material they're requesting, and often that's in advance of the actual hearing commencing. It might be the day before or a couple of days before, and I would echo that sentiment. If you're interested in getting it, make a request as early as you can.
Particularly if there's footage, which is what the media want first and foremost. If there's footage of something, a car accident or a scene of crime, that's what they want, because that gets onto the...
Because, and it may be nuanced. It may not be a decision like Judge Gaynor was saying about yes or no, you can have it, or no, you can't have it. I mean, you know, a case I remember involved the driver of one vehicle on a freeway going at the applicable speed limit, veering into the emergency lane of that freeway and collecting a tow truck driver who was in the process of putting a car which had broken down onto the tray of the tow truck. Now, as it happened, the tow truck had a camera on the rear of it which captured the entire incident. Now, up until the point of contact, that was quite relevant in showing, you know, like words can't, what the incident involved. But what happened after the collision, which was horrifically and graphically detailed, it just wasn't appropriate to release it. As I say, if there's going to be an application for that type of material, CCTV camera footage or photographs, you know, a judge may need to consider it in some detail. So an early application is beneficial for that.
Yeah, in fact, I've just sort of thought, sorry, Mike, in a case like that, one of the things you'd be thinking about is, you know, the tow truck driver's family being re-traumatised.
Yeah.
And it being...
And he survived.
He survived, you know, that the whole... And it becomes viral, the more violent, it's more likely to become viral, and they're traumatised over and over and over again. Those are the sorts of things you take into account. Yeah. It's not just a question of going, oh, this is proper, this isn't proper. It's about what effect is this going to have on particular people. And, for example, sometimes where you've got a crowd scene where you know, a crime happens in a crowd scene, you've got perfectly unattached, innocent people being included on this film, and they don't ask to be publicised all over the media either. So those are the sorts of things that you sort of have to weigh up. And so, as Judge Gamble just said, you know, you'd allow the film in and of it, the truck veering off so people can see what happened, but no one needs to see the gory aftermath because of the sorts of things, as I take it, as Judge Campbell, you took into account in deciding what you did. Yeah.
And so is there a middle ground potentially? So say there's a minute of footage and there's a section in the middle there that is graphic and gory. Can a judge make a decision to approve the release of the material but have a certain part blocked out or blurred out?
Absolutely.
Or potentially, in some cases, release photos instead of footage? Is
totally.
I think there's a capacity to pixelate people's faces. So, yeah, there is potential for that.
You can say, yeah, you can have this material, but on this condition, you need to do this, this and this, and this bit comes out. Yeah, of course you can.
And just on that topic, if I could just add, the court's experience of the media on these sort of really sensitive graphic exhibits is overwhelmingly very positive.
Yeah.
We have a good faith relationship with, for example, the main TV networks who would be most interested in this material. And I can think of dozens of cases where we've released vision or pictures on certain conditions and they've always been adhered to. So it does speak to the professionalism of the core professional court reporters that cover the courts. I think, you know, it's in their interest to you know, fulfil those obligations. It also helps the court to know that we can trust them to make the necessary edits in the event that there's a time sensitivity. So again, I think the fact that relationship is there really helps both parties.
Yeah, and I guess further to that argument then, if a journalist were to, or a media outlet were to make a submission to try and get footage or whatever exhibit it might be, would a judge be minded to, would that help the argument by suggesting that edits or those sort of cuts can be made?
Yeah,
absolutely.
Well, I think the journalist has to consider, what do I really want and need from this material, and only request what is absolutely necessary. And that will only advance their argument. If they spend time trying to argue about material that clearly is not appropriate to release, you know, that's not going to assist their argument.
It's often about timing as well. Sometimes you don't want to release material until you've finalised the matter because it won't make sense on its own. And that's particularly the case, of course, in a trial where there might be some evidence that's gone in footage. And indeed, there was a trial that I was involved in where there was quite substantial footage, but the person was only convicted of a small part, and the rest would have been highly prejudicial and unfair to put out. And at the very end of that trial, what was released was just the portion that made sense with the way that the jury decided.
Fantastic. We've got a great question here that talks about our media is increasingly going digital, and just more specifically with suppression orders. Do suppression orders cover social media? If there's tweets or there's a Facebook post or something that breaches suppression order, could that be brought before the courts?
Yeah.
And so with that sort of situation, would that be punished the same way, say, a news article would be, or how would that go forward?
Well,
That's a good question. I think it depends who actually publishes.
yeah.
But I imagine that will become complex in the future as to whether the social media platform themselves has any responsibility or over an individual's, say an individual gets a hold of something that they perhaps shouldn't have because it's been suppressed. I don't know, maybe he can answer that. Is there
It's an evolving space, and there's also overlapping reforms with defamation area of law where the companies are liable for what is posted. In brief, you certainly can breach an order through a tweet or a Facebook post or an Instagram live or a TikTok.
But as to who is breached?
Well, in my experience, it's generally the individual who's posted it. However, I think it's an open question. We might need to note that and get back to that question as to the
it's a good question.
the law. Yeah,
it is a good question. Yeah.
We've got another one here, changing gears slightly.
Yeah.
In terms of, I guess, the way that judges are perceived in the media by some, I should note, there is, I guess, a theme that judges may be lenient in their sentencing. Does that ever become a consideration when you have a sentence before yourselves?
No.
I think I answered that earlier by saying no, we don't have regard to what the media may project or imply as to what an individual judge's sentencing practice is. Thankfully, that doesn't happen very often, and certainly not as often as it used to. But from time to time, there are occasions when an individual case gets a lot of publicity and the individual judge is included in that. Sometimes that warrants a response from the chief judge. But, you know, I can only, stress that it's important that reporting is balanced and informative, and I think we've made quite some progress with that in recent years, including for high-profile cases, for example, having a link to the actual judge's sentencing reasons, full sentencing reasons, which are included on the court's website, but can also be found often on websites such as Ostley or Jade.
Also, that's where the immediate publishing protocol is really important. That's why we actually brought that in, because when a judge hands down a sentence, they don't just sit up there and say, I'm releasing you on a community corrections order, good luck, goodbye. You actually have to write. You have to give a lot of reasons for sentencing. It's a bit like writing an essay. You know, it'll be, generally speaking, a sentence will include a description of the offending, a description of the offender's history, their prior history, their social history, the psych reports, and then a description of why the judge has reached the decision that they have, because you have to describe all the reasons for why you have come to this conclusion. And that can be quite hard for journalists because there's a space imperative. You know, you've got a 2-minute story for radio, you know, you've got a 3-minute grab for a TV report, or you've got a certain number of paragraphs that you can write for a news story. So it can be very difficult to include all of those. And so what the immediate publication protocol does is it means the judge, when they're delivering their sentence, got a copy of that sentence and they hand it down to the journos straight away. And so and that's been quite successful, so that the journo will either write or report on radio or TV the story, but then they'll provide a link for the person either reading it or listening to it, so they can click on to the judge's reasons for sentence and find out exactly why the judge has gone that way. Because it's a matter of considerable frustration for judges that you spend a lot of time working out the sentence. You've got a lot of things you've got to take into account, and then it doesn't get reported. It doesn't get highlighted. The sort of careful thought exercise that you've gone through just doesn't get any publicity. Just get, the accused did this and this is what they got, and no one knows why. And they think, what's that idiot judge done?
I think, as Mark said, and as Liz just said, I think all these initiatives we've put in place have improved
it. Yeah.
But this perception that we're lenient, I'm reminded of, there was a recent study of Victorian jurors, and who had sat through the trial and found the person guilty, and then they were provided with the judge's sentencing remarks at the end. So they knew the whole case, they knew what the judge had said about sentence, but wasn't given the number, the sentence at the end. 62% would have sentenced more leniently than the judge.
Yeah.
And on average, I think it was more than 50% of those would have sentenced on average 12 months less than the judge. So when everyone knows the facts and the whole story, the perception fades away that we're lenient. In fact, the opposite would seem to be true for people that have heard those facts, but of course coming at it from a lay perspective. And so again, that's where the media plays such a critical role in education, in communicating with the community, so they understand that there's a lot more to it, and when they do, those perceptions are often different.
At the same time, like I said, space and time are difficult for journalists, but the reason why we sentence as we sentence is incredibly important, and that is actually often the thing that is not least reported. I mean, sometimes there will be, but the link between the crime and the sentence that's decided upon, the reason why this happens, the past of that, what the judge has taken into account, that just gets left out of a lot of media reports, often for understandable reasons, but it's still enormously frustrating. And then when you've got particular news organisations that have a view on law and order, and they will make a sort of editorial comment about it without referring to what the judge has done and why, that's incredibly frustrating. And I think it underlines a great deal of this notion that we are lenient. I mean, we all live in the community. We all want to live in a safe community, and that includes us. Anyway, yes,
and
sorry.
Look, the court and individual judges don't want to stop reporting on cases, far from it.
No.
But what we would ideally like, and I think are entitled to expect, is balanced reporting, which plays a very important role in informing debate in the community. And there will be differing views about particular aspects of the law. Let's have a debate by all means, but let's make it an informed and balanced one.
Yeah,
that's
right.
Fantastic. And Judge Gamble, to that then, if I may, if, say, during a plea or a further plea, there's media reporting that targets a particular individual or an accused that is either wrong or potentially defamatory, is that something that a judge might consider in terms of extra punishment? So there might be, in a sentence, that might be added in as potentially extra punishment?
That's very possible. For example, if a particular case and that particular accused was of great interest to the media, and if they reported the personal details of an accused, which sometimes comes out in open court, such as, for example, where they might be working at that particular time, that may have ramifications. That may end up resulting in that person losing their job. Or just the sheer volume and nature of reporting on a particular case can get to such a level that it's a form of punishment of and by itself, an additional form of punishment to what the court may otherwise choose to impose on that person. And in certain circumstances, a court can take that into account as one of the relevant factors.
Yeah. It's called extracurrial punishment, and it's something you can take into account, and a barrister can legitimately argue that press coverage of this person has had such a damaging effect on their personal life that's it amounted, as Judge Gamble just said, to a form of extra punishment in itself, and you can moderate the sentence down, taking that into account. Yeah.
And would there need to be a special hearing for that consideration, submissions or anything like that?
It doesn't matter. It goes in the mix.
Just goes in the mix.
And could that potentially make its way into sentencing remarks?
Yeah, absolutely.
It should.
You should. You say, I'm taking this into account, and why?
If you are taking it into account.
If you are. Yeah.
Yeah.
And from a media's standpoint, would there be any follow-up potentially with the journalist, the media outlet, if something was deemed to be particularly aggressive in the report?
Yeah, it's a good question. I think particularly for any journalism students who are listening, I mean, it sort of circles back to our point about criticism of judges. I don't want to speak for the whole judiciary, but I don't think any judge minds informed criticism. And if someone assesses the case law, the relevant sentencing legislation, and then writes an article saying, I disagree with the outcome the judge has imposed here, I don't think any judge would be upset about that. If there's an error at law, for example, it's a matter for the Court of Appeal and you can report that. But where it's misinformed is where you start to get into strife, because it's misleading. And again, I go to the extracurrial punishment. Again, if you're right in what you have written, there's very little the courts or anyone else can do to you. That's the key. It's being accurate. And so, for sake of argument, if there was a case where someone was accused of child sex offences, now that's a very fraught area because there's a lot of legal definitions there that don't necessarily match contemporary language. And if a person is accused of being a sort of sex offender that they are not at law, that can be technically wrong, inaccurate, and again could see that person being recognised as having extracurrial punishment. So really the advice from a media front is, don't shy away from criticism. I mean, don't think that the courts are telling you shouldn't report X, Y, and Z fact in a case if your editorial decision is that it is relevant, but just be aware that you must be accurate. That would be my position.
You're also asking, Ryan, that would there be repercussions, and they would certainly be that the offending journalist would be spoken to and contacted by the media team. Yeah. And the other thing is what young journalists need to know as well is that if a journalist does report in that way, like really inaccurately and unfairly, that becomes known amongst other judges. And other judges think, they get wary of that particular reporter. So the next time the reporter said, you know that this particular reporter is fronting up and they want information, they're covering the case, gee, we didn't, or she did, on the last time they reported something. So the judges themselves, if the name gets known, and judges themselves think you need to watch this one. You're there as a journalist, you're entitled to do your job, but to do it sort of like mid-ground, respectfully and with sort of information. And if you do need to stand up in court, have a look at because it's a hard ask, but say your editor says, no, get up and tell them we want this. If you're talking to the court, do it really respectfully, because that's what barristers do. Not because you necessarily have to suck to a judge, if I could put it that way, but because the judge is going to be far more open to listening to your request and answering your request if you do it with a certain amount of respect. I mean, that's a very rough rule of thumb, but if you're coming to the county court, get in touch with Ed or Ryan and they will be your best guides to what to do next.
Fantastic. Thank you very much. That concludes our session for today. Thank you to Judge Gaynor, Judge Gamble and Judge Wraight and Ed for such a great discussion. And thank you to all of you who attended today and asked so many interesting questions.